Good day, Crime Talk aficionados. It is Saturday, August 13th, 2022. That means all of the top stories throughout the week located in one convenient location right here. Hope you enjoy it. Have a wonderful weekend. We'll see you next time. Now, as you may recall, we had a conversation the other day regarding the Lori Vallow, Chad Daybell matter and the fact that everything's been sealed. And I've been complaining about this for a long time. And then a retired attorney by the name of Lori A.G. Hellas filed a motion basically saying, hey, you can't do this, Judge. Now, the motion hasn't been ruled on. And we'll hopefully have some more information for you in the next coming days about Ms. Hellas's motions and hopefully some good orders for us. But let me give you an example of the Judge Boyce, who's handling the Lori Vallow matter, should follow. And that is a South Carolina Circuit Court judge by the name of Clifton Newman. Now, he rejected a joint motion for a gag order submitted by defense attorneys and the prosecutors in the double murder case of now disbarred attorney Alex Murdaugh. The order instructs both parties that efforts to suppress pretrial publicity were denied. That marks a kind of a major win for judicial transparency in the ongoing Murdaugh murder saga, which has previously been noted is much bigger than just a double murder. We've talked about that from the beginning, that this case is going to be big. Some people don't like it. I don't get it. You got a guy that kills his wife and his son to cover up his illegal activities, and yet people act like, no big deal. I don't get it. Anyway, the South Carolina system is basically, for lack of a better term, put on notice that there shouldn't be any sort of secretive backroom deals that Alex Murdaugh and his powerful attorneys can do without public scrutiny. At a hearing back in July down there in Walterboro, South Carolina, the defense attorneys for Alex Murdaugh moved that all parties to the case ought to be gagged from speaking to members of the media, and that key motions related to the upcoming trial should be handled in secret. It was a little surprising because the DA went along with it. Well, the Judge Newman, a very staunch advocate for judicial transparency, made it clear he was not happy with the joint motion, noting that he specifically disfavors court orders which sought to limit pretrial publicity. And his quote was, "It's a public matter." Sound familiar? Well, that's what the judge said. It's a public matter. It's a public trial. Now, the judge told the attorneys to submit their motion regarding the pretrial publicity in writing, which took place sometime last week. And then the judge said, nope, not going to do it. He is committed to keeping his courtroom open. Now, the prosecutors, when asked for some comment, basically said, hey, we are already barred from discussing pending cases by the state's rules of professional conduct, as are all attorneys. Let's get that straight. You can't go out there and say false stuff that's going to go out there and influence people. The gist of this is that the defense attorneys didn't want embarrassing information coming out. The man is charged with a double homicide. Sound familiar? How much more embarrassing could it be? Well, maybe for Alex Murdaugh, it could be that a South Carolina sex worker by the name of Lindsay Edwards has come forward, and she says that basically she was in the involuntary sexual servitude business, and during the time that she was involuntarily serving people, guess what? She had 4 occasions to find herself with an attorney from a personal injury firm in Hampton, South Carolina, and that guy's name just happened to be Alex Murdaugh. That's right, one of the wealthy men known apparently to this little madam's black book for sure. Now, it's alleged, according to this young lady, that what transpired during those encounters, well, according to Miss Edwards, Murdaugh liked to choke her to the point that she nearly blacked out, gagged her, beat her, and pulled clumps of hair from her. So things just get a little more weird down there in South Carolina. But this is a good time for perhaps our legal quote of the day, don't you think? And I think it goes to the judge there. The judge weighs the arguments and puts a brave face on the matter. And since there must be a decision, decides as he can and hopes he has done justice. Well, I think Judge Clifton has done justice for everybody out there so that we can actually see what takes place in the court filings. That is huge. And saying no to the attorneys, no matter who they are, however powerful they think they are or may be. And shame on the district attorney as well. They work for the people, and their job needs to be to make sure that everyone sees the case. It's a public trial. The public has a right to know. I will say that to the bitter end. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Former President Donald Trump said he refused to answer questions today at a deposition by investigators for the New York Attorney General's office, and specifically Letecia James, as part of her civil probe into his business activities. Now, Mr. Trump announced that he had invoked his Fifth Amendment right against making self-incriminating statements shortly after arriving for his scheduled court-ordered deposition under oath. He put out a statement and said, quote, "I once asked if you're innocent, why are you taking the Fifth Amendment? Now I know the answer to that question," Trump said in a furious statement that railed against James as a renegade prosecutor with a vendetta against him. When your family, your company, and all the people in your orbit have become a target of an unfounded, politically motivated witch hunt supported by lawyers, prosecutors, and the fake news media, you have no choice, according to Mr. Trump. Now, accordingly, under the advice of counsel, and for all of the above reasons, I decline to answer the questions under the rights and privileges afforded to every citizen under the United States Constitution, he said. Now, a spokesperson for Attorney General James did not respond to any requests for comments, but in an unrelated criminal investigation, Trump's deposition came 2 days after the FBI raided his home at Mar-a-Lago Club in Palm Beach, Florida, where they seized what his attorney said were about a dozen boxes of documents. That search was related to an ongoing investigation into whether laws were broken when boxes of White House records, which included some documents marked as classified, ended up at Mar-a-Lago instead of the National Archives. And we'll see how that plays out. It's unprecedented, but if crime's been committed, I get it. Just seems a little overboard for some records. It seems like something most attorneys could usually negotiate or return to the National Archives. But there's an easy way and there's a hard way. Everybody always picks the hard way. But on a positive note, it is good to see that Mr. Trump is finally listening to somebody, including his attorneys. Now, when the other side is asking you questions and you could possibly be exposed to criminal prosecution, you have to exercise your Fifth Amendment rights. And remember, anything that you say can and will be used against you, misconstrued, and taken out of context. I have told many a client over the years, it is better to look guilty than to be found guilty. It's in the Constitution. Okay? I've said this once and I will say it again. Listen, if they are interviewing the subject or want to speak with the subject and they have not filed charges or anything along those lines, my advice to my clients is always don't say a word. If they had enough to charge you, would have done it by now. Do not give them any wiggle room to make it so that you get charged. Now, for those of you who are not familiar with the Fifth Amendment to the United States Constitution, here's a quick little tidbit about it. The Fifth Amendment of the United States Constitution addresses criminal procedure and other aspects of the Constitution. It was ratified along with 9 other articles in 1791 as part of the Bill of Rights. You know, the first 10 amendments. The Fifth Amendment applies to every level of government, including the federal, state, and local levels in regards to U.S. citizens or residents of the United States. The Supreme Court furthered the protection of this amendment through the Due Process Clause of the 14th Amendment. It states, no person shall be subject, except in cases of impeachment, to more than one punishment or trial for the same offense, nor shall be compelled to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor be obliged to relinquish his property where it may be necessary for public use without just compensation. So, except in cases of impeachment and cases arising in land or naval forces or the militia when on actual service in time of war or public danger, in all crimes punishable with loss of life or member, presentment or indictment by a grand jury shall be an essential preliminary. In a press conference this afternoon, the New Hampshire Attorney General confirmed police are investigating who murdered Harmony Montgomery after new evidence indicated that she was killed in December of 2019. Now, Harmony Montgomery was murdered in Manchester, New Hampshire, in the beginning of December of 2019. That's what the Attorney General, John Formella, now says. Now, Harmony was officially reported missing in December of 2021, although she has not been seen for years. Now, court documents released earlier this year indicate that police received a call from Harmony's biological mother, Crystal Sorey, on November 18th, 2021, who claimed her daughter was missing. Sorey told police that Adam had physical custody of the girl and that she couldn't get in touch with him. Now, Sorey added that she lost custody of Harmony in 2018 due to her own drug issues. And according to Sorey, Adam Montgomery blocked her calls, blocked her from social media, and didn't allow her to speak with Harmony after the Easter celebration in 2019. New Hampshire police reached out to the New Hampshire Department of Child Services to try and locate Adam, but by December of 2021, the agency couldn't find him. Police began searching for Adam Montgomery when they learned that Harmony had not been physically seen since October or November of 2019. And then on December 31st of 2021, police located Adam Montgomery sleeping in a car in New Hampshire with his current girlfriend. The girlfriend told police that Adam never once talked about Harmony, and Adam reportedly told police that Harmony's mother came to pick her up in Manchester, New Hampshire around Thanksgiving of 2019. Now, Adam claimed that he hadn't seen his daughter since. And in June, the FBI, Manchester Police, the United States Marshals, and the State Attorney General office arrived last week at the Manchester home where Harmony's father, Adam Montgomery, and his wife, Kayla Montgomery, lived with Harmony before she vanished. The Manchester Fire Department set up an incident tent while the city's Department of Public Works dropped a camera into a sewer pipe while FBI agents watched the camera view from the utility truck. Investigators were hauling a large refrigerator wrapped in black plastic out of the apartment, along with other items wrapped in brown paper bags. Now, the search preceded a 2019 incident which Adam Montgomery was accused of abusing his daughter. Police spoke with Adam's brother, Michael, who said that Adam hit Harmony and gave her a black eye. Police then reached out to Adam Montgomery's cousin, Kevin, who witnessed the alleged incident. Quote, "I bashed her around this house," Adam Montgomery said, according to the cousin Kevin. Kevin told investigators that Adam was upset at Harmony when her infant brother started crying because he told her to keep an eye on him. In anger, Adam allegedly spanked Harmony, made her scrub a toilet with a toothbrush, and forced her to stand in the corner for hours. Now, Harmony's remains have not been located. Now, listen, I'm not the smartest guy in the world, but I don't think it takes a genius to figure out there's two possibilities here, right? Either homicide or this child was sold during some sort of human trafficking. Clearly, I think the child is now deceased, but it didn't take me that long to come to that conclusion. It's not like she ran away. It's not like she ran away. It's kind of the master of the obvious, I guess. Next on the docket, is Letecia Stout crazy or just crazy like a fox? Well, Letecia Stauch's third mental health evaluation has been submitted to the court, which was needed before the murder trial could move forward. For those of you not familiar with the Letecia Stout case, she stands accused of killing her stepson Gannon inside their home near Colorado Springs back in 2020. Her two previous evaluations indicated that she was competent to stand trial, and the court noted nothing can be done and the case can't move forward without this report, according to the judge, Gregory Werner, and hence the reason why they had to set the matter over for the evaluation that is being completed by the Pueblo, Colorado Mental Health Institute. And the latest evaluation was filed with the court, but details are not known at this time. They file it a little early so that each party has an opportunity to review it, and then they are all going to return on August 25th to see what the verdict is, so to speak, and see if this case moves forward. As you may recall, the new defense attorneys went with a somewhat limited defense of not guilty by reason of insanity without trying to say not guilty of reason of insanity, but there was enough of the magic words used, so therefore an evaluation was completed. Now, Letecia Stauch has had several evaluations done, as we noted earlier, and she also has tried to allegedly escape twice, once on the transport back from the extradition from South Carolina, and then once from the El Paso County Jail. So obviously I don't know what's in the report, but my guess is they're going to say that she is completely competent, and everything that she said in that evaluation is probably going to be able to be used against her as well. So, Letecia Stauch, crazy or crazy like a fox? I think the thing that Letecia Stauch forgets is that she's not the first person that's been in this particular situation. The court's been dealing with these types of situations for a couple hundred years. And guess what? They know, and the professionals know, if someone is in fact faking it. We'll wait and see. 25th, we'll see what comes about. Now, based upon Letecia Stauch's internet history, it's reasonable to believe that she was possibly unhappily married to Mr. Stauch and had some degree of resentment toward the family as the step-parent. Now, the affidavit that's been produced in this shows that Letecia appeared to be researching a move to another state to a 2-bedroom apartment. Stauch was the sole caregiver at the time of the boy's disappearance and death. Now, Gannon lived with Stauch and his father, Al Stauch, at the time of his death. And Al Stauch was on a work trip with the United States National Guard in Oklahoma when his son vanished. Gannon's biological mother, Landon Hoyt, was in South Carolina, and Gannon's body was found months later under a bridge in Pace, Florida. According to the affidavit, Stauch brutally attacked and killed Gannon inside his bedroom, despite a neighbor who said his video showed Stauch leaving with Gannon that morning and later returning home alone. Investigators believe that Gannon likely did return home with Letecia that afternoon and died inside the residence. Evidence from inside Gannon's bedroom includes blood splatter on the walls, blood that soaked through the carpet, 50 droplets on the wall, blood on the wall socket, and blood on the boy's mattress. And based on the orientation of Gannon's bed, the vast majority of the blood would be in line with the position of his head and torso. Additionally, investigators have evidence and a receipt showing that a purchase for baking soda and carpet cleaner and trash bags purchased on the 27th after 6 p.m. Investigators obtained Stauch's phone, and according to text messages, she instructed her then 17-year-old daughter to buy the items for her. Prosecutors allege that Stauch used the purchased items to clean up the crime scene, and investigators said the 17-year-old was likely not present when Gannon was killed. Now, Letecia Stauch faces charges of murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. Obviously, we will give her the presumption of innocence. Let me know. Crazy like a fox or just crazy.